Welcome to Drunk Beaver Productions. I'm your host, Jonathan, and today we're going to take a look at a day in court. We'll join Judge Picorni in the 7th Judicial District of Kansas for her first case of the day. Next, we'll drop in on Magistrate Braley in 14B for a morning and afternoon double feature. Finally, we'll wrap up in Judge Mott's 30th Judicial District for the last case of the docket. Start the countdown.
First case I'd like to call are the in custody State of Kansas versus Jacob Roberts, 2024 CR 190. Would you state the appearances, please?
Senior Assistant District Attorney Ricardo Leal.
Jacob Roberts appears by video from the Douglas County Jail and by counsel Brenda Clary by Zoom from a separate location. Judge, on March 7th, the court ordered a competency evaluation. I have not yet received the report, and at least as of this weekend, I do not believe the evaluation has been completed. So, and also, Mr. Ketchel assures me that he promptly forwarded the order to Bert Nash. So I guess we have no choice but to continue the matter for a week or two and see if we get a report.
I like gambling. Let's keep doing that. I mean, let's keep doing that. I'm good. Let's keep gambling. Throw me back in for another month, week, year, whatever.
Mr.
I got it coming. I mean, don't talk to my mom about it. I mean, if you looked her in the face or anywhere in her body, you'd see that she has not sustained any injuries, but you made sure I couldn't talk to her.
Mr. Ketchel did follow up on that. Ms. Clary and Ms. Godina said it would take about 2 weeks. We're right at the 2-week mark, so we should be getting that any day now. So okay. I'll push it out 1 more week.
1 more week. And I'm sure that under the circumstances that Mr. Roberts would like me to ask for pretrial release assessment.
I think he had an assessment, and I have the assessment. But I don't actually see a pretrial release order that was sent with it. I'll try and follow up on that.
I appreciate that.
Okay. Then thank you, Mr. Roberts. You're excused. We'll see you next week.
Thank you, Your Honor. I believe that's my only case on the docket. May I be excused as well?
Yes, you may.
B District Court is now in session. This is Magistrate Hillary Braley presiding, now calling case number 24S00045. This is the State of Michigan versus Tyrell Henderson. Can you please state your name for the record, sir?
Tyrell Henderson.
Thank you. What I have here is a misdemeanor complaint that charges that on or about May 24th of 2023 at you did fail to provide an animal with adequate care and or negligently allowed an animal to suffer unnecessary neglect, torture, or pain, and it did involve the animal's death. That is otherwise known as cruelty to one animal involving the animal's death. Do you understand that charge?
Yes, Your Honor. Who? And
okay, that is here. Okay. That is a misdemeanor with a maximum penalty of up to 1 year in jail, a $2,000 fine with court costs, or both. Do you understand that potential penalty?
Yes, ma'am.
Count 2 alleges that you did fail to provide 2 or 3 animals with adequate care and or negligently allowed 2 or 3 animals to suffer unnecessary neglect, torture, or pain. That is otherwise known as cruelty to 2 or 3 animals. Do you understand that charge?
Yes, Your Honor.
That is a misdemeanor with a maximum penalty of up to 1 year in jail, a $2,000 fine with court costs, or both. Do you understand that potential penalty?
Yes, Your Honor.
And did you have a chance to review an advice of rights form?
Yes.
Okay. Do you have any questions about your rights?
Not at all.
Say it out loud. Okay. Thank you. Okay. Attorney Plumai, your appearance.
Yes, Your Honor, Assistant Public Defender Alexis Plumai appearing with and on behalf of Mr. Henderson, and to address bond. I believe the bond recommendation from the prosecutor's office in this case is for a personal recognizance bond. But I would note that my client has been in jail for the past 276 days on another matter, and bond is still denied on that file. So I would just respectfully request a very low cash bond just so that he can start to accrue automatic time credit on this case.
Okay. Thank you. The court will set your pretrial conference date as April 16th, 2024. That will be at 9 a.m. over Zoom before Judge Washington. And the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to purchase or possess a firearm, ammunition, or other dangerous weapons. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court, so that next one for 14B District Court being the April 16th date. You are not to purchase, possess, or adopt any animals in the interim. You are, okay, I think that is everything then. At this time, the court will set a PR bond. Attorney Plumai, if you don't have anything else, and sir, if you don't have any questions for the court, then this hearing is concluded, and sir, you are free to stand up and tell the jail that you're finished.
Thank you, Your Honor.
To the device ending in 0094, You were just let into the courtroom and can hopefully hear me at this point. Can you hit *6 to unmute and tell me who you are?
Hello?
Hi, can you tell me your name, please?
Kalicia Fifer.
Okay, thank you.
Wow.
Okay. Now calling case numbers 23S0081 as well as 21S00499. These are the State of Michigan versus Kalicia Fifer. Attorney Plumai.
Assistant Public Defender Alexis Plumai appearing with and on behalf of Miss Fifer.
Ms. Fifer, hit *6 to unmute and state your name for the record, please.
Kalicia Fifer.
Okay, thank you. Okay. Today is the date and time set for an arraignment in the matter ending in 181. What I am seeing is
This case should have been over.
bond violation. So it appears that you have not been testing as per the community corrections report.
Yes, because of you people had called and told me to turn on my device.
Fifer?
So I did as yes, ma'am. Yes, Your Honor.
Okay, so you were also ordered to go to community corrections.
And I did. And you guys restarted my device after I turned in my doctor papers to you guys. So after I turned in, do you see my doctor papers on file to you guys? After I turned in my doctor papers and stuff, then that's when the judge reordered and restarted my testing. So I had to call. They restarted the testing. When they restarted the testing, they didn't know the monitoring people. They didn't tell the monitoring people. So the dude named Brian called and said, hey, we got to come pick up your device or you need to drop it out for community corrections. So I did it, and I dropped my blowing device off at the office. After I received a warrant, I called Brian Levitt, and he said, Ms. Fifer, this ain't your thing. It's not your fault. You did as follows. He said, just going to restart this. Now, we've been going through this case for so long just to get a final settlement.
Ms. Fifer? Ms. Fifer.
Yes, yes, yes.
Okay, I can hear that you are upset, and this has been going
I'm very
on for
upset.
a while. Yes, but I am going to ask the public defender to speak on your behalf at this point. Attorney Plumai.
Thank you, Your Honor. It sounds like there was some confusion with regards to the testing requirements. I would just request a personal bond on Ms. Pfeiffer's behalf, and that we reiterate and explain those requirements to her so that she can get into compliance with those.
Thank you. Give me just a moment. Okay, Ms. Fifer, you may unmute. Okay.
Yes, Your Honor.
So you were last in front of me on February 21st. And at that point, you had informed me that your SoberLink device was in your impounded car. So I had ordered you to report to community corrections within 48 hours so that you to get the SoberLink.
Yes.
Yes.
Exactly.
Okay.
And I did as follow. And then like 2-3 days when the lady had restarted it, she said, you could do this over the phone. She said, she had called me and she was like, oh, I can call you tomorrow and we're gonna restart the device. So we restarted the device and I started back blowing again. And then we was called and the dude said, Ms. Fifer, we got a court order to come and pick up your device or you need to turn it in. So I did that. Brian Levitt, then when I heard I had a warrant for it, that's why I called Brian from Community of Corrections. He was saying, oh, Ms. Fifer, I see where this happened. He said, when the time when you was in the hospital, before the 21st, before I got to restart it, you guys didn't tell them. They didn't know. So he was like, Ms. Fifer, it's nothing you did wrong. He said it was a miscommunication between you guys. That was not on my fault. I did as followed.
Okay. So I hear you.
No,
ma'am, thank you.
Yeah.
I do hear you. I can understand that this is very frustrating. I do have a note on ma'am. Okay. So I do have a note that says that you came in to community corrections on February 27th, placed the device on the counter and left without any explanation. So at this time, the court is going to...
I was called on the 26th, Your Honor, to turn in the device.
Okay.
That's why I did. I was called.
Okay. Ms. Fifer.
Yes, Your Honor.
Okay. I hear what you're saying. If going off of what I have to go off of here in this report, you walked into community corrections, put the thing on the counter and left again. So.
That's what I was told to do.
Okay.
Can you call the dude at the office and ask him?
Okay.
He called, he said, Ms. Fifer.
Okay. So my point being that walking in, putting it on the counter and leaving without talking to anybody at community corrections resulted, well, in any case, this can be addressed at your next court date with the judge. Attorney Plumai. I believe.
Your Honor, as to bond or?
Yes.
I would just request a personal recognizance bond on her behalf, and that she report to community corrections or get back into compliance with testing that's ordered within 24 hours.
Okay. Thank you.
Your Honor, can it please be 48 hours? I am in Brighton.
Thank you for that information, Ms. Fifer. So at this time, I am going to set your next court date for April 4th.
For April when? I'm sorry.
April 4th.
So I'm going to here and pick up the device again. What am I doing?
Your next court date is going to be April 4th, 2024. Okay. That will be at 10:30 in the morning in person at the 14B District Court.
This one in person?
You are coming to the 14B District Court in person. Yes, for your
Do
next.
you guys have buses everyone there, Your Honor?
Say that again.
Do you guys have buses everyone there?
Yes, the bus does come here. What is that? 46, I think.
Mm.
I don't, I believe it's Route 46. You should check that though, but bus service does come here. Yes. I would imagine too, if you call the public defender's office, they'll also have information for you. As
Do
far
they
as
have bus tokens too also as well?
they have, I'm sorry, I'm having a hard time understanding what
Do they
have?
also have bus tokens, Your Honor? Because we've been dragging this case for so long, it's unbelievable.
Okay, no, I don't. The bus tokens, you'd have to ask somebody other than the court. I don't have
So
any. for you.
why is it guys so important to come in person than me to do it on Zoom?
Because at this point, I'm ordering you to come to the court in person so that you can see
Yes.
the judge. So,
I'd be more than happy to see it. Who is the judge? Elaine Washington?
yes,
Is this a final settlement?
well,
For
it's
the
going to be,
time?
okay, it is going to be a bond violation hearing. I don't know that you have reached the final settlement conference stage yet. So, in any case, you're going to have your court date in person, April 4th, 10:30 in the morning. And at this time, the bond is continued, as is the bench warrant. Attorney Plumai, do you have anything else?
No,
I don't
thank
tell
you.
you. I'm sorry, Your Honor. So I still have the warrant?
Yes, you do. So at this time, the hearing is concluded. Attorney Plumai, presumably your office can reach out to her with more information.
Yeah, we can.
Okay, thank you.
State of Kansas versus Braden Black, 24 CR 65. Party state appearances, please.
Good afternoon, sir. Larry Marchinsky, County Attorney on behalf of the state of Kansas in this matter.
Good afternoon, Judge. Braden Black appears in person via Zoom with counsel Kelly Reynolds, also via Zoom.
All righty. Mr. Reynolds?
Thank you, Judge. I believe this is first appearance we're set for today. We would just request time to make sure we have all discovery on this matter, but we'd also request the court's permission to address a bond condition, if Your Honor would hear that at this time.
Okay, yeah, go ahead.
Thank you, Judge. I believe he is ordered to have no contact with anyone under the age of 18 due to the allegations in this complaint. I would notify the court that he does have a nephew who is 10 years old that resides with him during the week with the initials BY. That's created complexity in his life and for the minor child's life. That is his place of residence during the week. So we would ask for at least an allowance to be around that nephew, who again is 10 years old, initials BY, but also that the minors involved in the allegations were closer to the age of 18. I believe they were, well, closer to the age of 18, I guess is all I can proffer to the court at this time. And also the charges, even if they were taken as true, it's not something that the defendant is alleged to have gone around and done repeatedly, or a dangerous living situation or something of that nature. I believe, just involved with the flee and elude allegations on this, Judge. So we would ask for, one, that no contact restriction to be lifted, and two, in the alternative, at least to be lifted with regard to the nephew.
State's position.
Judge, I'm sorry, I'm going to object. Honestly, there may be full merit to what Mr. Reynolds is asking for, but this is the first time I've heard of it. I'm sorry, but I strongly disagree. I think that Mr. Black's behavior was exceptionally reckless and put two minors' lives at risk. Obviously, the nature of these charges don't have anything to do with a 10-year-old nephew, and it's not like we're talking about sex or anything like that. But at this point, I haven't had an opportunity to review that. I don't know. And obviously, I love Kelly. He's a great attorney, and I'm sure that he's an officer of the court, and he would never lie to the court. But I don't know the truth of any of this. And I haven't had any opportunity to review that. So at least for those reasons, I would object, Judge. But I do acknowledge that the two passengers in the car that I've alleged endangering of a child, they were both 17. So and I'll just leave it with that. But just because I haven't had an opportunity to review or anything, if there had been a written motion that I could have looked at or been prepared to make an argument today, I may have had a different recommendation. But at this time, I just have to object.
Allegation he's driving a Polaris and endangered minor child JT, born in 06. Who's the other one? Doing 92 miles an hour, 92, you know. Was there 2 kids on the Polaris?
And again, to call them kids, Judge, I agree with Kelly. They're both 17. They're virtually on the verge of being adults. But according to the laws of the state of Kansas, they were still minors.
Judge, the other one was SF, and I would note additionally that neither of those two are the nephew in this instance.
Yeah, okay. Well, let's just say he can have contact with his nephew, but he can't be driving a motor vehicle with any children in the car. I'll modify it that way.
Thank
I'm
you,
sorry,
Judge.
Kelly. What was the initials of the nephew again?
BY.
Okay.
Contact with BY, but still he's not to be driving any vehicles with BY riding along.
Understood, Judge. Thank you.
So that'll alleviate any problems, I'm thinking. All right. We could, I guess it's a felony. Do you want to set it for prelim or just set it over to get discovery?
Yeah, I would appreciate a control date or status date, and then I can announce for prelim at that time if Your Honor would allow it.
That's fine. When do you want this set over?
If we could go over about 30 days, I would appreciate it.
All right. Any objection?
No, sir.
All right, April 11th.
Would that also be a 3:30 setting?
Does that work for me?
Yes, it is not on my list.
All right, April 11th at 3:30.
That works. Thank you, Judge. Via Zoom again?
Yeah, Zoom's fine. If you want to show up personally, that's fine too.
Thank you.
All right. Nobody wants to drive to Wellington. Saver Brian Fleming, 23 CR 300,058. Mr. Fleming?
Yes.
I mean, Mr. Reynolds. I'm sorry for Mr. Fleming.
Thank you, Judge. Same appearance as the last case, but with Brian Fleming appearing via Zoom. I think I saw him. Yeah, he's there.
Yes, sir.
So I believe we have a control setting on this one. I would request maybe just 2 or 3 more weeks. And at that time, I can announce whether we're going to waive or have evidence, if Your Honor would allow it, or if Mr. Marzinski doesn't object to it. That would be the defense's request.
You
No
want that
objection, sir.
April 11th date? Is that fine?
That would be great.
All right, continue to April 11th at 3:30.
Thank you, Judge. And is that all you show for me today?
That's all I show for you, and that's all I show for me.
Oh, excellent. Well, thank you for the